So we're going to talk about the new law and changes, obviously effective January of 2014. There are some of my brethren out there that are literally saying that you don't have to redo your documents for 2014, that the law is applicable in 2014, and that means you have to do all your year-end documents in 2014. I can't think of anything that is farther from the truth, because there are pivotal provisions in the statute that talk about penalties if you have not done these proper mailing of notices and the year-end documents. Who wants to be the manager who says to your boards, you can't increase your assessments because I did not get out all of the documents in the year-end package? That is a penalty now that's written into the law. And it's such a big deal. Let's assume I'm wrong and everybody else is right, or whoever has that position is right. Why wouldn't you at least want to hedge your bet to get the documents out so they are compliant with the statute? Originally, when the Law Commission was asked by the legislature to rewrite Davis-Stirling, it was supposed to be just reorganization and renumbering. As we all know, and if you don't, you'll likely know after we're done, they made a number of substantive changes, 14 big deal changes. One of the things that we won't have is we won't have all the subsections. Each new section of the Davis-Stirling Act will be a standalone section. So currently 136303 is gazillion different subsections and subsections, and it makes it hard to find the applicable provision. Concentrate more on the substantive part of it and don't get caught up in the numbering. There are all these great tools out there to help us translate the numberings from one to another. We have it on our web, on our blog. We have laminated copies. I'll have them shipped to your office if you need them, because they're really a very good tool. And so that really shouldn't be our concern. It's mine too. I mean, I've been, for all these years using those code numbers, and they were second nature to me, so we'll all be learning them together. Supposed to be easier to understand. I'm not really sure that's accurate, but we're going to give that our best shot. So what has changed? Well, I'm going to just briefly tell you the big ticket items of what has changed, and then obviously I'll be breaking them down into substantive matters for you. I will take questions as we go along. It won't ruin my mojo. If I don't call on you, it means I'm at a point where I really feel I need to go. Just give me a second to repeat the question so it makes sense for who might be hearing this again in the future, and in case the people in the back could not hear. So the new changes include changes to delivery and notice to both members and the association. And we'll be talking about provisions that just never existed before. There were no definitions for certain notices before. We will finally have what I call the DUH section, conflicts of interest for board members. So the day before yesterday, I taught this class in Orange County, and I spent 3.5 hours in a meeting. That should have been a sign that things were not going well, with a board where 2 of the board members, 5 homeowners, 5 board members. It's in their documents that has to happen. And they were fighting because they wanted to be able to vote on matters in which they had a conflict of interest because they didn't think it was fair that they didn't. So I keep on joking, this is duh, like everybody should know what conflicts of interest are, and I thought it was sort of interesting that in the middle of this storm, I actually had a meeting with somebody who didn't understand it and didn't want to agree to it. The year-end disclosure statements, there are a bunch of new things, but there's some old things as well, and things that really should not make us nervous. We have a checklist. We put it in your packet. So when you're going through your documents, just make sure that all of the things on the checklist are checked off, and you will know that you've complied with what the statute requires, so that you're not in that awkward situation of not being able to enforce the association's assessment increase. The year-end packages are going to be put into 2 packages. One is the annual budget report, and there's 5 components to that, so that's sort of easy, and they're all documents in some manner, although they have a little bit different name that you're used to. And then the other is the annual policy statement, and there's 11 components to that, and some of them are new, and they are a little tricky, but nothing really that should be throwing us. New definitions and terminology, I have no idea why this was done, but we do have the new definitions, and we'll go through that. Hierarchy of governing documents, I call this DUH2 because we always know law is controlling, then CC&Rs, then bylaws, articles, bylaws, and then rules and regulations. And interestingly enough, they didn't put the condo plan as a document that is in the hierarchy, and I find the condo plans to be very important when really having a difficult time in assessing, is this association maintenance or condominium unit owner maintenance. Grants of exclusive use common area, the 67% requirement for members to approve a grant of common area remains. However, those things that the board can do unilaterally has been increased, and so we'll go through that as well. Election results, how they come about, and what you do with that information. Records inspection, that for the most part is the same. Provisions affecting assessments and liens. There actually was a law that went into place this year, but you'd never know it by how many people did not realize this, and I think that's part of our failure in not getting the word out. But effective this year, and absolutely in the new Davis-Stirling Act, you're supposed to note when the board votes in executive session to foreclose, not to record a lien, but foreclose, in the next set of general session minutes, you're supposed to go in and notate that decision with the APN number. So that has to go in your next minutes, and yeah, so if, okay, everybody, starting January 1st, we're going to all make sure that we do that. And Tracy, do we put our APN numbers in our authorization forms that go to the board for approval on the notice of sale?
Yes, it's on the actual board resolution to initiate foreclosure.
Okay, so the answer is yes. It's on the board resolution to initiate foreclosure, so you don't have to worry about going to title to getting that number. You can rely on it and obviously use it when you are preparing your next minutes.